We're going to have Bill Symmes and Amy Mensik are going to talk about when accommodations collide. This is a really interesting topic. They presented this at the NORMA conference. I'm not sure how many of you attended the NORMA conference, but this was presented there, so they're going to present it for us here today.
Well, welcome back, everybody. Is my mic working? Okay, thank you, and thank you, Kaylee. Again, this is going to be a presentation on when accommodations collide, primarily religious and disability accommodations. But before we begin, I'd like to recognize two people. Over here is Brian Rakofsky. He's our firm president, and I want to thank him for coming out. And then I saw Mary Giannini. Mary, where are you? Mary Giannini, if you all know, Mary for a long time was part of our, and in many ways is still an emeritus part of our labor and employment group. She's starting to slow down and retire, enjoy the finer things, I guess. But I want to say thank you for her coming. I know a lot of you have worked with her and you know her. In fact, I've done many of these presentations with her, so I wanted to recognize her and welcome her as well. So with that said, we'll begin. Amy, you're up.
And is my, no. And is my. Is that on? Can you hear me? All right, in the back as well. All right, not a tech CLE. Thank goodness. All right, so as Bill sort of foreshadowed here, this is, when accommodations collide, and that basically is, am I going to get sued by two people? You know, it's hard enough to accommodate one person and deal with, accommodating them through the process as well. But this is kind of to flesh out the scenarios that based on the colliding rights or obligations to two employees, whether I'm going to get, I'm going to have an issue with both and kind of fall between a rock and a hard place. So that's kind of the issues we want to ferret out here, and they're very interesting scenarios. And my clicker, I found it. I need an accommodation to find my clicker. All right. With that said, presentation overview. As Bill mentioned, this is going to be disability and religious, because those are the two areas of the law that require, quote unquote, accommodations. So it's sort of a presentation overview here. Disability accommodation review, it's really going to be like blitzkrieg disability accommodation law. We're going to get through it, but I just want to highlight some of the key terms because it's always good to revisit these issues and to refresh, because this is really such a tricky area of the law that's not black and white. No matter what you do, every case you have. So we're going to do an overview of some of the core concepts in reasonable accommodation in terms of disability. Then I'm going to turn it over to Bill, and he's going to do some of the core concepts and very interesting issues with vis-a-vis religious accommodation and the differences between accommodation in the disability context versus accommodation in the religious context. And then we have some hypos for you, some interesting scenarios to kind of do a skills practice on some of these concepts that we're going to discuss. All right. So accommodation laws, again, disability, Americans with Disabilities Act, Washington Law Against Discrimination, broader. We all know in Washington here, we are broader than the Americans with Disabilities Act as opposed to other folks in, for instance, Idaho, who are subject to the federal definition of disability and the ADA. Religion as well. Title VII governs religious accommodations and religious discrimination, and also our law against discrimination in Washington does that as well. All right, so quick primer and overview on the definition of disability. Like I said, might be kind of difficult to see in the back, but basically the ADA is, not, well, let's start with the Washington Law Against Discrimination. That is very broad. Basically, as opposed to the ADA, it doesn't have to substantially limit a major life activity. And for instance, major life activities can be sleeping, walking. At other times, plaintiffs get creative on what might be major life activities. For instance, one of my favorite cases involved a woman with a multiple chemical sensitivity disorder. She said she was inhibited in her major life activity of shopping, and not only shopping, but detergent shopping. So these are the types of things that people call major life activities under the ADA. And I won't go through, the ins and outs of both of them, but basically the takeaway from this is the Washington Law Against Discrimination is much broader than the ADA. But that being said, the ADA, after the ADA-AAA amendments in 2009, also broadened the definition to include, for instance, episodic conditions such as cancer, epilepsy, things that aren't always, active. But when they are active, the ADA recently said that that would be a disability when they are active. And as Bill foreshadowed earlier, the ADA, not the Washington law on discrimination, though, does have some explicit exclusion of what's not a disability. And particularly for our case, gender identity disorders are explicitly excluded from the definition of the ADA. So, and some of these, for the WLAD, for instance, methadone prescriptions, that can be implicated in the disability laws. A wound, as we talked about with the Crees case, and as we'll get to later, what about an allergy to Japanese cherry blossom? That scent, is that a disability? And we'll discuss that later. Yes is the answer, but we'll get there. All right, another core concept of reasonable accommodation for disability is what is a reasonable accommodation? And you all have gone through this, so I won't belabor the point, but basically, what will enable the person to perform the essential functions of their position, but also it's not necessarily limited to that. Equal access to benefits and privileges might be something you have to reasonably accommodate someone in. But in terms of the job, here's a laundry list. We all know generally what it is. Leave, modifications to structures, reassignment to a vacant position if they're not qualified for the current one is always an important one that employers often forget. Providing readers or interpreters, or modifications to existing policies. What does that mean? But again, these are some, as we all know, just examples of what a reasonable accommodation in the job may be. What is not a reasonable accommodation? It's eliminating essential functions of the position, fundamental job duties, creating a new position, providing personal items. You don't have to buy someone their eyeglasses if it would help them, outside of work as well. Changing supervisors or something that is something that often comes up, like I'm stressed out by this person, I want to be moved to a different department, so I'm not so stressed out. That generally is not a reasonable accommodation, as even our Washington courts have held. Tolerating misconduct. That's a great one there that always is tricky, especially in our circuit. Many of you may be familiar with the notorious, so to speak, Gambini case about a bipolar woman who they knew she was bipolar, but she threw a tantrum, flipped over furniture after a performance review, and they terminated her for that conduct, saying you cannot have outbursts like that. But there was an open question that outburst was, quote, part and parcel of her disability. Therefore, you may still be liable if you terminated her for that. But that's a tricky area, but you'll notice in your materials in the disability section, it's not without limits. Making threats to coworkers. I think there's a case in there where an employee actually threatened to shoot his supervisor's children in the kneecaps. Not something you have to accommodate, even in the Ninth Circuit. And one of my favorite cases is the EEOC v. Walgreens case, also in the materials, where a hypoglycemic employee ate a $1.39 bag of chips because she was having her blood sugar was low and she was restocking the chips, and she's like had to eat them right there. She inevitably forgot to pay for them or something like that, or there was some dispute. But Walgreens had this no holds bar, absolutely no grazing policy. They lose $750 million per year, so we're absolutely strict with this. The court said no, it's not just your policy overall, you have to look at the specific circumstance with what's happening with the employee. And so their $1.39 bag of chips turned into a $180,000 bag of chips in this scenario where they had to settle for that amount. So misconduct, not so black and white either. Essential functions, again, just a primer on this. We basically, what's important to your business? What is so essential? What is the fundamental duties of this job? What is something I can't live without here, or what is something I shouldn't have to live without? But again, just think about fundamental duties is the ADA definition, and that's sort of a working, use that as a working model. What are some examples? Is regular and predictable attendance an essential function? That's a hot button topic in terms of folks who wish to telecommute for whatever reason. Ability to work overtime. Working well with others. You can kind of phrase these in certain ways, in kind of unconventional ways, aside of just showing up on time or leaving at a certain time. It can be other things that are not so tangible. And For our purposes, ability not to violate anti-discrimination policies. I think that's a pretty essential function of someone's job, but you don't really think of it that way. But as we go through these cases, you'll realize that actually that can be something that really is something that is obviously important to us, even though it's so obvious that you don't think of it. All right, so undue hardship. We've all heard this term, and how that fits in with the disability accommodation analysis is the quick line is you have to reasonably accommodate a qualified person in order for them to perform their essential functions, et cetera, unless that accommodation would cause an undue hardship. And the difference here is we don't usually want to get to the undue hardship analysis in law because it's the employer's burden to prove. And it's a really difficult burden. But the nutshell here is you never have to provide an accommodation that is an undue hardship. And importantly, in the disability context, it is a very high employer burden, and I want to preview that to contrast with what Bill will talk to you about in terms of religious accommodation and what is undue hardship in the religious context. So working definition, something that requires significant difficulty or expense, but it doesn't necessarily have to be tied to finances. Something can be burdensome for non-financial reasons, as we'll see in some of these cases, allowing someone to actively discriminate against his gay coworkers, not really a financial issue, but certainly something that's going to cause you a hardship. And this is going to be difficult to see, but here's generally what this slide has is it's a list of cases where the employers actually were able to establish undue hardship, and that's often difficult. Particularly, there's this Adegobe Tay case where we're all familiar with after someone's FMLA leave expires, you still have to consider the disability analysis, whether they're entitled to more leave under a disability analysis. But it's kind of like, where does that end? Where do I draw the line? How much leave is too much? I don't know, when does this stop, this slippery slope? When does the slope stop? This case, the slope actually stopped and the court agreed with them. And in this case, it's because the employer took really good, had really good facts and really tracked how it was impacting their business. They had to hire temporary help. $8,000. There was uneven care. She was a nurse by use of other temporary employees. And there was also resident complaints, fatigue with the other nurses. So the employer, the important takeaway with hardship is don't just say, oh my gosh, that's going to be difficult for me, or speculate. Have the facts that back it up as why. So that's in general what these slides point out in some of these cases. Ray V. Kroger case is an interesting one. It was actually an employee with Tourette's who could not help but blurt out racial slurs. And and he was a clerk in a grocery store, and they tried to move him around that he'd be away from customers, but inevitably he kept interacting with people, and he couldn't help but blurt out these racial slurs. They said even though he wasn't meaning to do this, it wasn't his fault, and he couldn't help it, and it was because of an obvious disability, the employer still did not have to accommodate someone who can't but help to blurt out racial slurs. So that's kind of a quirky example of how this can play out in very unique scenarios. What is not undue hardship? I touched upon this again, presaging what Bill will say, not a de minimis burden. What does that mean? But there's really no this one's not. But not based on, assumption or hypothetical facts. Have your facts straight. One important thing is in these disability cases, even if you're arguing over whether it's a disability or whether something's an essential function, I think it's always important to be building the facts of how this is impacting my business. Again, the slippery slope. This may mean you may have to go down the slippery slope a little bit. Keep having people coming in, keep racking up how much business you're losing. That's kind of what undue hardship is looking at, actual impact. And importantly, for our purposes, generally grumbling by coworkers. They always come in, why is this happening? Or I don't like this person. The grumbling, I just call it. The grumbling defense is not going to work in an undue hardship disability context, and as we'll see, even in a religious context as well. All right, another core concept, again, this is kind of blitzkrieg disability. The interactive process, we all know what this is, the exchange between the employer and the employee to ferret out these issues of whether someone has a disability. What are the essential functions of the position? What is the accommodation you're asking for? How will that help you? That back and forth. Again, not a mandatory process under the law, but if you drop the ball, you're going to lose the case, frankly, is what it is. So the goal here is not to drop the ball. So when you're going through this, one of the points I just want to point out for the interactive process that is so important, especially in these quirky cases, these non-traditional disability or religious issues, if you're going to say something like, if you're going to have an outburst like, that's not a disability, don't write it in an email internally, like write it to your lawyer or something like that. You want to make sure, because that will come back. That will come back, and it will kind of show, as in some cases have, they point out the fact that the employer was questioning or kind of flip about something as evidence of a failure to accommodate, even though ultimately, you really did all that you could. But in a moment of pressure, this one email just gets highlighted and blown up and, encircled and sparkles put on it by plaintiff's counsel. So you want to absolutely be very careful that in the interactive process, you always wear the white hat and be the most reasonable person in the room. Especially with these non-traditional, I don't know what a traditional disability is, I keep saying that, but kind of these ones that we haven't come across that you'll see in some of the hypos, but what if you need more information? What if you literally get a reasonable accommodation letter from a provider that is the employee's mom or something like, they're just obviously a quack. Can you do something about it? Yes, you actually can under the ADA, and the EEOC has guidance on this, so don't forget that you do have tools in your toolkit when you're facing this somewhat, kind of an unfamiliar territory, that you do have an ability to request other information. But you can't always, of course, you can't request too much information. If you have sufficient info on whether something's a disability, what their limitations are, how something will enable them to perform the essential functions, you do have to stop and, of course, keep it confidential. But one thing I did want to point out again, as I stated earlier, is that be careful of GINA. Make sure you find that safe harbor language for your ADA interaction, so that ensure that in case you accidentally do get genetic information, that you're protected from that. All right, so as part of the interactive process, one line that employment defense attorneys always make sure we highlight is, in theory, you do not have to provide the reasonable accommodation that the employee wants. Inevitably, in practice, it always seems to focus and circle around that. The regulations say you should give preference to this, but this is important, especially in this context where we're dealing with some, I'm going to keep using the non-traditional context, but some newer, quirkier accommodations. I think this is very important to be like, okay, you don't necessarily have to go with that specific accommodation that employee is requesting, but that should trigger you like, okay, are there other ways I can explore this? But in general, to back up, the principle here is at the end of the interactive process, you as the employer are entitled to select the accommodation, not the employee. But again, in practice, it might be a little different when someone comes to you and they're hyper-focused on this accommodation. But again, your choice. All right, well, that was a very quick and dirty overview of disability accommodation. So everyone got out that, we can all accommodate someone. Let's walk out the door and go accommodate someone. But
Quick and dirty?
Quick and dirty.
I don't think it was very dirty, but okay.
Oh, I'm sorry, I should have been dirtier. All right.
Thank you, Amy.
Yeah.
Take your book, will you? Clicker, please.
Something with
It's
our
like
clicker.
surgery.
We have like
It's
a
like the
problem with
remote
the clicker.
control at your house. Who's got it last? Where'd you put it? I left it in the kitchen. It's in the refrigerator. Well, I'm going to talk a little bit about religious accommodation, and it's like Amy mentioned up front, is there's really only two requirements of accommodation in the civil rights laws. Can everybody hear me with this? Okay, great. And it'd be religious accommodation and disability. And as you'll see, religious accommodation, it's pretty much the same as a matter of fact. Legally, it's a little different, and I'll walk you through the steps. And then when I get to the end of this, we have some hypotheticals, and we've been providing a lot of information today, unilaterally, or if you will. And for many of you who have seen either me and Kim or whoever do seminars, we usually like to get you all involved. So when we get to the hypotheticals, we might ask you some questions, or feel free to ask questions. We've been racing through this stuff so quickly, but we don't want to stop you from asking questions. And of course, during breaks, ask questions. And I think we are allocating a certain amount of time at the end of today for questions. So our goal is not to try to prohibit questioning, and so please do. So I have to look up here. Religious accommodation duty. So Title VII and WLAD, Washington Law Against Discrimination, there it is. Requires an employer, once on notice, to reasonably accommodate an employee who sincerely, another buzzword, held religious belief, practice, or observance conflicts with a work requirement, another buzzword, unless providing the accommodation would create an undue hardship. A lot of familiar terms in there: undue hardship, accommodation, and accommodate. Oh, I said accommodate. Reasonably. There's another common word you see in the law, which means it depends, right? Isn't that the lawyer's answer to everything? It always depends. So, what are the elements? This is how we're taught in law school. What are the elements of a failure to accommodate religious claim? Well, let me back up for a second. I didn't want to go there quite yet. Reasonable accommodation duty. We are going to talk about accommodation, but I should always stop. Religion obviously is a protected class, and as a protected class, that means it has the traditional causes of action too. You have disparate treatment, which is the direct discrimination you make, hiring, firing decisions, or any sort of decisions based upon one's religion. An example would be what happens in smaller family companies is they hire a number of people maybe from their church. If they're very active in church, they hire a lot of people from the church, and that often can create what people perceive to be as bias. And bias is just a more benign word for prejudiced or discriminatory. And remember, prejudice just means to prejudge based upon some sort of criteria that's not relevant to the issue. And so you may have favoritism. Well, favoritism can lead to disparate treatment claims, or with regards to how you run the workplace, with regards to holidays or the working hours, if it has an impact on one particular religion or the other, that can create a cause of action. And so you got to look at your policies to make sure that they're not biased, they're not providing any sort of preference to one religion or another. And again, like any disparate treatment, in order to prove the cause of action, you'd have to show that whatever employment action is being taken, it was motivated by the person's religion, or as we say in Washington, the substantial factor. So it doesn't have to be the only reason. Of course, if you have disparate treatment, you can also have then the more ambiguous animal, and that is hostile work environment. Because we all know from the sexual and racial cases that in addition to prohibiting specific employment decisions based upon a protected class, an employer may not allow an environment or a culture to develop which in and of itself creates those biases or preferential treatments for one person over another if it's a protected class. That's really all a hostile work environment is. People think in terms of abuse. People think in terms of incredibly hostile or abusive behavior. It doesn't have to be that. It just has to be a pervasive, ongoing culture that can create disadvantageous terms and conditions of employment for one protected class over another. So if it's based upon religion, no different than based upon gender or race, that is also a cause of action. So you have religious harassment. Quick note, I assume most of you have this now, but any sort of sexual harassment policy you once upon a time had should have been a long time converted to an anti-harassment type of policy covering harassment based upon any protected class. Then, of course, with this case, we have an accommodation cause of action, which is akin to disability. In disability, we have disparate treatment, intentional discrimination. We have disability harassment, hostile work environment against those who may have some sort of medical condition, to put it in most liberal terms, and then failure to accommodate. Elements: employee has a bona fide religious belief that conflicts with an employment requirement. Do their beliefs or practices interfere with maybe one of the job requirements, one of the policy requirements of your company? The employer is informed of the belief in conflict. The person is disciplined, threatened, or otherwise subjected to an adverse action due to failure to comply with the requirement. Adverse action, there's that word we hear over and over again, at least us lawyers, and that is some sort of employment decision that impairs or has some sort of quasi-negative impact on a term or condition of employment. It's not just a demotion, it's not just a lowering a raise, it could be the forbearance of giving somebody a raise. It could be a number of different things. And in fact, if you recall from the panel discussion, I gave an example where simply disclosing to you shareholders that so-and-so has brought an EEOC charge and you believe it lacks merit, which you would think would just be one defending their position and expressing opinion, given the circumstances, the EEOC found that to be an adverse action, notwithstanding the fact the person had not been employed there for 9 months. You can probably tell now what my opinion is of that decision. Anyway, I'd like to focus first on element number 2, I believe. Yeah, informed employer of belief in conflict. Okay, so this ties in a little bit with the interactive process, which I'll talk about briefly before we get to the hypotheticals. But it's also akin to the same thing when you're trying to determine to what degree somebody is on or needs to take FMLA leave, to what degree somebody may have a disability because of that. There's got to be some sort of investigation. But you're all probably also familiar with the Washington Administrative Code regulation that provides all those do not ask questions for interviews. So it's not as if you can walk in and if you look at the regulation, I believe it says questions over religious beliefs, it says you may not ask anything. Okay? So what's difficult is what happens, like if you're trying to hire somebody, but you need to know to what degree they may have some sort of belief that would conflict with an employment requirement. Okay? Here's the EEOC. Well, first of all, the employee request. Okay? It's a new or should have known kind of test. It's what I call a Monday morning quarterback. That in this, it says the employer need only have enough information about employees' religious needs to permit the employer to understand the existence of a conflict between the employee's religious practices and the employer's job requirements. But don't ask anybody about their religious beliefs, but you got to figure out what to do about it. Okay? And that's the rock and the hard place. And that's what's difficult. Now, we heard Ms. Haynes earlier today talk a lot about the Abercrombie and Fitch case. I'm not going to go into nearly the detail, but she highlighted some important things, and one of which was that was a case where the person who applied for the job wore a particular religious head garb, and the person wore it to the initial interview, and the person that interviewed that lady, there was no issue or concern with the head garb per se. She was in fact qualified for the next round of interviews or to be hired and then to go through the orientation. Abercrombie, as you heard, had a number of different policies and beliefs, one of which was with regards to the look policy. Is that what it was called?
Yeah.
You had to look a particular way, and hats, headgear, head garb, whatever you may call it, didn't fit the image of whatever these 15-year-old kids were supposed to have looked like. You can tell that based on my age now. I don't really follow Abercrombie. There's got to be somebody in the room like me that remembers once upon a time when Abercrombie and Fitch was not a teenage store, but you could go there and you could literally buy a croquet set, polo shirts, shorts. Does anybody remember that store? Come on, Terry. No? All right. Used to be down by the South Street Seaport, Mr. Rakofsky. In any event, what happened in this case, which is unique about this case, and I jotted down some notes here, is at first there was concern about whether she could meet this look policy if she's wearing the head garb. And there were discussions and emails by and between the people in management, and there was concern about it. And therefore, in the end, what the decision was in essence not to hire her. Whether she had a pre-hire qualified offer until she passes something, I don't know. Of course, it's not that clear. But the bottom line is this. The court never got to the accommodation issue because the decision was made without any sort of effort to communicate with this person about whether her belief would conflict with the requirement of having to look a certain way. Requirement being you got to look like you're a 15 model. Religious belief, I have to wear this head garb that probably wouldn't fit the typical average American 15-year-old image that they wanted to portray. So they made the decision, let's just not bother with it, and they didn't hire her, or they let her go, whichever one it was. The point of that is where the Supreme Court came down, Justice Scalia, was that this was a disparate treatment case, meaning it was simply this. It wasn't about whether she could have been accommodated, couldn't have been accommodated, or not. They never got there. The decision, the substantial factor for the reason that the person was not hired, adverse employment action, was that the hat. or the headgear, which was part of her religious belief. So they didn't even try to accommodate her. They didn't even get to the analysis of whether they could. And that's what's important here. Explicit request, you don't need to specifically ask. I said earlier, you're caught between a rock and a hard place. How about this? Is there anything, when you during the interview, when you discuss what the job is, you discuss the job requirements, you discuss the schedules, the requirement for overtime, and so forth. Is there anything about our job requirements or any condition of this that you could not meet? That's one way of exploring it. You can ask, to what degree is there any part of this job, think of the essential functions, that you could not do? You don't ask, do you have a disability? You don't ask, do you have a religious belief? But you ask and see if they provide that information, because at that point in time, then you can maybe start to explore further. Leads to the next question, and I'm going to go back to element 1, bona fide religious belief. I have all these cases, you guys could read it. I've read them, I don't even know what the answer is. Religion includes all aspects of religious observance and practice, as well as belief. Includes theistic and non-theistic moral ethical beliefs about the right and wrong, which are sincerely held with the strength of traditional religion. Then we have atheism, Wicca, which Amy told me it's witchcraft.
Hocus pocus, yeah.
And it's been recognized as a religion. Traditional organized religion may even be illogical views held by only a few or even one person. Typically, this is probably the most important part that I see the courts focus in on, is typically concerns ultimate ideas about life, purpose, and death, afterlife. Why does the human being exist? Some of those deeper questions. Does not include mere personal preferences, social, cultural, political, economic philosophies, whether it be the KKK, trickle-down economics. What was the one with, there was something about cold fusion, and a scientist's belief in cold fusion, he wanted to say it was a religion. The court said no. Secular lifestyle choices like veganism or yoga.
Yoga, maybe.
Yeah, yoga.
Maybe on yoga.
Depends, maybe hot yoga. The law is kind of all over the board right now, and I know that this is becoming more and more prevalent in everybody's practice. The legal test, I wrote this down. A number of the courts write this, that religion for purposes of the statute involve fundamental and ultimate questions having to do with deep and imponderable matters.
Religion, right there.
They are comprehensive in nature, a belief based upon a system as opposed to an isolated teaching. Often recognized by symbols. Okay? The EEOC says religious beliefs, this is actually in a Q&A, you can find this online if you go to the EEOC.gov and you can go into their Q&A, and it says religious beliefs include theistic beliefs, i.e. those that include a belief in some sort of God, as well as non-theistic, moral and ethical beliefs, which we have up here, as to what is right or wrong or which is sincerely held. All courts generally resolve doubts about particular beliefs in favor of finding that they are religious beliefs. But those religious beliefs which are not protected are the ones that are not strongly held in a traditional sense. I can't track this. So what they say is that they say it usually concerns ultimate ideas about life, purpose, and death. And then it gives examples. Attending worship services is usually an example of somebody who follows it's a religion. Praying, wearing religious garb or symbols, displaying religious objects, adhering to certain dietary rules, proselytizing, and other forms of religious expression. So I guess the point of the story is, and let me go to these 3 cases here, is it's difficult to follow. Friedman, veganism is not a religious creed. And in this particular case, this was a worker who worked at a facility where you had to be inoculized for mumps. So you had to get the mumps vaccine. But his belief was you cannot use anything from animals. You cannot, I can't remember exactly, but it had to do with you couldn't wear leather, you couldn't eat anything from an animal product, made from an animal product, couldn't wear animal product, and so forth. And so in this particular case, he refused to do the mumps vaccine because it's grown from chicken embryos. The court analyzed that and came down, and what they really focused in on was this notion of it doesn't go to those deep, imponderable matters. It wasn't about human existence. It was about really your feeling about animals. Court came down and said not a religion. Compel, this one's great. Compel versus Department of Corrections. This is a person who applied to be a corrections officer, and the requirements of the job said the hours could fluctuate and you could have significant overtime, even and if there was a riot, you could work up to 16 hours. Well, this guy started his own religion. It's called sun-worshiping atheism. Let me read you the tenets of this religion. 1, you must pray to the sun. I don't even know, this may not work in Seattle, but you got to pray to the sun. 2, you got to get fresh air. 3, you need to at least sleep 8 or more hours every day. 4, you have to eat and drink when you want to. You have to exercise frequently. You must take rests. And you must be social. People, this is from in the Court of Appeals. That means there were 2 lawyers for both sides of this spending a lot of money to go to court, to go to trial, and then go up on appeal. This is what, I guess that speaks for itself for me, but because of that, they found that this was not a religion. EEOC versus Red Robin. This is a case, notice the state. So 2 California states find no religion. Washington, we find a religion. This is a guy working at Red Robin. And he adopts an ancient but dead religion from Egypt, an Egyptian religion from Pharaoh times. And without going into the detail, he became, there was only, not very many in the world. There's very...
It's like him and like some other guy.
Yeah, it was like him and some guy had lied. and they put the tenets of this ancient religion online. But they went through the process of they made themselves priests and they got ordained in that sense and a number of things. But there was a God and it did discuss imponderable matters and deep questions of life and existence of human beings. And in the end, our court ruled that it was a religion and therefore the person had protections. The issue we'll talk about a little later in the hypotheticals is that part of the religious sect was that you got, or part of the ceremonies, you got certain tattoos. And the tattoos represented the people who had come before you and the afterlife and stuff like that. And therefore, and it was a sin under the religion to cover them up. Well, Red Robin, I guess like Abercrombie, has an image issue that you have to look a certain way, be a certain way, and if you don't, it'll destroy their image and people won't buy hamburgers from you. One of which was no piercings, no tattoos, and so forth. Well, the question was this a religion? 1, and the answer was yes. Therefore, could they require him to cover it up? I'll talk about that later when it comes to accommodation, but that was the issue there. So that is an example of a type of religion. The point is this, okay? I always go into these elements of these claims. It's important for it to understand them, but in the real world, focus on the interactive process, focus on whether there's an accommodation, and don't get too bogged down on whether there's a religion because, frankly, it's all over the map. It's a dangerous position to take, such as what Abercrombie did, where they just say, we're not going to look into it. Okay, so here it says, you better believe it. We'll tip rarely, if ever, delve into the delicate business of whether religion is bona fide and sincerely held, because it could be an ancient Egyptian one, or it could be a guy who just wants to be able to sleep 8 hours a day, eat and drink when he wants, and lay in the sun. Okay, but what you get sometimes is the person might act in a manner that's completely inconsistent with the belief. So they're using religion as an excuse, if you will, and you don't believe it. The problem is that sometimes the employee's belief can change over time and therefore really doesn't lack sincerity. So let me read something again out of the EEOC handbook, something that I look to frequently, not as much because I believe it, not as much as I agree to it, but it shows me where the federal government is going from the agency standpoint. The EEOC does not promulgate laws. It eventually has to go to court like the rest of us, but yet they're the regulatory agency, so they get to unilaterally tell you, until such time as you're in court, what they think is right or wrong. But here's what they said here. They said that Title VII requires employers to accommodate only those religious beliefs that are sincerely held. Well, that's helpful to you all. And that can be accommodated without undue hardship. Although there is usually no reason to question whether the practice at issue is religious or sincerely held, if the employer has a bona fide doubt, there's that on the grade, about the basis of the accommodation request, it is entitled to make a limited inquiry into the facts and circumstances of the employee's claim that the belief or practice at issue is religious and sincerely held and gives rise to the need for accommodation. Factors, either alone or in combination, that might undermine an employee's assertion that he sincerely holds these beliefs are as follows. 1, whether the employee has behaved in a manner markedly inconsistent with his professed belief, maybe drinking booze on the weekend when they're not supposed to even serve booze would be an example. Whether the accommodation sought a particularly desirable benefit that is likely to be sought for secular reasons, such as I have to go to Hawaii because that's where my pilgrimage goes to every year, sometimes in April, sometimes on Christmas, and for sure always on Fridays through Mondays, and so forth. But the point is they do like to make clear that sometimes a person's belief can grow over time. I'm Catholic, Irish Catholic, not hard to tell. Well, am I the Irish Catholic that goes to church just on Christmas and Easter? Maybe so. How many Irish Catholics, since I'll poke fun at myself, do that until they get older and all of a sudden they go from church to twice a year to twice a month to every single Sunday? That's not acting inconsistent. That's just type of growing. The bottom line is it is a risky place to be. So, what is a reasonable accommodation? And there's a number of examples, but generally, just like with disability, you don't need to give the precise accommodation. It needs to be one that works, and it doesn't have to eliminate all the religion-workplace conflict, but a majority of it. And of course, if there isn't one available, then no duty to provide it. Potential examples, work scheduling. Example around the Sabbath, I have a client that I got a kick out of this one because it's more unique if you live in the Northern Hemisphere like we do. Seventh-day Adventist. You have to be home by sundown on Friday. Manufacturing facility, 3 shifts, days, graveyards, and swing shifts. There's some overtime issues and coverage depending on demands. Well, June 21st, guy can work to about 9:30 in Colville, Washington. In December, can work to maybe about 2:45 or 3. So the question, how'd they accommodate that? And they did. What they did is they worked around work scheduling. You can do lateral changes. So in other words, as long as they don't get demoted, but you can look at other shifts maybe. That's an example. Leave for pilgrimages. For those of you who hire younger employees, maybe you have somebody who takes a job, has that job because they just got out of schooling or training for it, but they have to go on a mission. Okay? Leave might be one, whether it's paid or unpaid, would go to the analysis of hardship. Modifying dress grooming standards. We talked about the Abercrombie case, and I mentioned the Red Robin case. That's an example of that. Permit proselytizing, preaching. Amy's going to talk more about that. We have a hypo on that, but that one's important to what degree can you accommodate that? I mean, there's all degrees and differences. Be mindful and beware of the, probably say this in the undue hardship area, but be mindful if you allow your conference rooms to be used for anything from pampered chef sales. I don't know where that came from.
You dug deep on that one.
What's
good.
that?
That was good. You dug deep on that one.
I did. But for other secular reasons, if somebody asks that they want to hold a service or mass in there at the same time after hours, if you choose not to permit that one but permit the other, see, now that's that disparate treatment issue. So you got to be mindful of that. But more so than with disability, this question comes in line and is more intertwined with the analysis. An accommodation results in undue hardship when there is more than a de minimis, I almost asked you all to say it, but de minimis cost to the employer, which in this particular case, suffice it to say, is the burden is much less than in disability. Okay, so if you're going to do something, go for religious reasons, not disability reasons. It's easier to prove. No, don't take that down. But that's the most I can't read my watch. Most important part of that, you can see right here, it's much less stringent than undue hardship in the disability cases, and so that's important. So what is an undue hardship? More examples. So additional cost to lost efficiency, higher wages. That would be if in changing work schedule, let's say it requires you to pay extra overtime. That may be an undue burden versus having a shift schedule for the Seventh-day Adventists that doesn't change the cost or the efficiency. If it requires you to go hire somebody of a certain skill, that might be it. Discriminate against coworkers, the proselytizing. What if your religion, like we brought up earlier, is to preach the gospel in sense, which is maybe against homosexual lifestyles or whatever? The fact that even if you were allowing people to use the conference rooms, if that was being used for something like that, that is also violating your harassment policy and is violating federal and state law, so that would probably be the easier one. Deprive coworkers contractual and other statutory rights, whether it be in a handbook, a regular contract, or a labor agreement. You don't have to violate seniority rights is one good example, if they are in fact vested contractual or statutory rights with regards to conditions of employment. Cause coworkers to shoulder undue burden, impact ability to promote diversity and encourage tolerance and goodwill in the workforce. There was a case like that where the company was doing a diversity program and trying to promote more diversity, and one of the devout Christians continued to put up anti-gay material and other scriptures on the bulletin board to profess his side of the view. He doesn't get the equal rights of the employer. That would violate that. Where am I? About done?
Yep, we're running a little over, so.
Oh, she's telling me I'm done, so I'm getting the hook here. So here's more examples of what's important with an undue hardship. Let me end on here then. This is a good place to end. The Red Robin case. I told you about the covering up the tattoos. Here's what happened in that case is they wanted to say it was undue hardship because it would hurt the brand. And that may have been a valid defense. However, they let the guy work there for 2.5, 3 months, or even 6 months, I can't remember, without covering it up. So the employer came in well after the fact. They just showed an analysis that there was not a downturn in sales of hamburgers, French fries, or anything else. There was no direct evidence of that. Therefore, they found that just because you say it's an undue hardship doesn't mean that it is an undue hardship. Interactive process, information gaps. This is basically the same as we discussed earlier. Don't assume that, back up, you should assume if they're bringing religious belief questions to you to explore it in the way that I described earlier, kind of an open-ended question. You're allowed to make the limited inquiry, and it really is going to be a case-by-case basis. So just be careful. If you have questions, call legal. With that said, we're going to provide some hypotheticals, and Amy's going to start the first one called Gone to the Dogs.
All right. We'll just do this in a TED Talk type scenario. All right, Gone to the Dogs. During her first week of working for Caught in the Middle, Inc., CIM, a large employer with an office setting, Sandra had a severe allergy attack. A coworker was eating buffalo wings containing paprika, a spice to which Sandra has a potentially fatal reaction, including trips to the emergency room. Afraid of future incidents, Sandra went to CIM HR explaining she would like to bring a service dog to work who alerted to the trace presence of paprika. CIM agreed. Sandra paid $10,000 for the dog, Sniffer, who was trained up a few months later. The day Sniffer first came back to work with Sandra, a coworker and longtime CIM employee, Ashley, had an unexpected severe asthma attack due to Sniffer's dander. CIM placed Sandra on leave, explaining she could either return to work without Sniffer or remain home on leave. Did CIM properly sniff out the issues? Okay. Paprika allergy, is that a disability? Is pet dander allergy, is that a disability? As we were seeing, when it's active, even under the ADA, even if it's an episodic condition, if when it is active, it inhibits a major life activity. In Sandra's case, she literally was put in the ER when it's active. So yes, in general, consider these very quirky singular allergies to be possibly a disability. I have a number of other questions here, but I'm going to kind of just jump ahead. What is CM supposed to do in this scenario, and did they do the right thing? Another potential question is, what if instead of saying, yes, you can have this service dog, if they were like, well, wait a minute, let's consider some other things. That didn't appear to happen in my hypo, but it's not a hypo. This is a real case. This actually happened to the city of Indianapolis, and it is literally as I described it, a paprika sniffing dog versus an asthmatic employee. Anyway, so this actually did happen, and the city of Indianapolis had to settle this for $85,000. Facts as I actually presented them in the hypo, and basically what the problem was here is that they didn't really do anything. They're like, okay, just go home, stay away from the asthmatic person. What could they have done more? And here we obviously have a collision between two conditions that need an accommodation. The other two cases here are just kind of ferreting out the principle that yes, paprika allergies, Japanese cherry blossom allergies may be a covered disability. So what happened in this case? This case made the news. It was actually written in the New York Times. So a representative of the EEOC basically said that, the city of Indianapolis here, what they had to do was figure out something. Okay, thanks. Thanks, EEOC. I tried to do that and it didn't work. So what can you do? Many of us have heard of the Job Accommodation Network, and I believe they got a hold of this case and try to give some guidance to employers. And the Job Accommodation Network is an online system, and it's put out by the Department of Labor. And it actually has a laundry list of all these various conditions that you can actually click on. Someone has multiple chemical sensitivity disorder. What are some of the potential accommodations I can consider, including HEPA filter, something like that. And they actually have some guidance on service animals in the workplace versus employees with dander allergies. They do have some examples. For instance, HEPA filters, shampooing the dog, Skyping between employees if there has to be a shared space with employees. Basically, all these other things that will behoove you to show that you are actually trying to work through this obviously very tricky situation, and that will always work out better for you. I mentioned, could, for instance, the employer say, remember we discussed the principle, I can choose the accommodation. Can you tell someone, you can't bring that service dog? Well, it's kind of a different scenario. If they already have it, I think there's actually a distinction between whether they already have it or whether they don't. The Jan mentions here that you probably can't ask someone to you can't really ask someone to deal with their medical conditions in a different way. You can't tip someone out of a wheelchair and say, I think you can use crutches. You could probably do it, but in the service, yeah, you can do it. I have faith in you. In the service animal context, service animals are not like wheelchairs. There's actually a Montana case discussing how a service animal is sort of like a wheelchair. You just need to bring a ramp or something like that. It was actually a service animal that was slipping on the floor, so the employee asked for accommodation of putting non-skid pads down. And I'm like, well, a wheelchair won't defecate in your hallway. So I don't think that's quite an accurate analogy. But the point with that is...
If it's a human, you get millions of dollars.
Yeah, exactly. You get $2.25 million. But the point with this is that, there might be a distinction between if they have it already or if they don't. For instance, scent-free, no paprika policies, absolutely no under penalty of death paprika policies might have been something they could have considered. All right, so there you go, paprika sniffing dogs.
This hypothetical is actually, every time a lawyer tells you one thing, then something changes. And so part of this hypothetical will deal with, I said earlier that there's only 2 statutes that require accommodation. I'd argue there's 2.5. And here's why. So you have Kevin, has worked as a sales associate for a mega retailer, Humongo Hunting Company, for several years. He's always felt different. A few weeks ago, he was diagnosed with gender dysphoria. We know that, as Amy said, is not a disability as of yet. Eager to express his true identity as a transgender woman, Kevin began making changes, including informal name change to Kelsey, and wearing traditional female clothing, makeup, and long hair. Kevin, now Kelsey, also began using the common multi-stall women's restroom at Humongo, shared by Humongo females. Really? Humongo females?
Yeah.
And employees and customers.
I might have been late when I wrote this.
In the restroom, Kelsey repeatedly compliments female coworkers on their hair and asks about good places to buy pretty undergarments. Again, really? Pretty undergarments? I'm doing this one? Okay.
Weird stuff happens in there.
That doesn't seem right. I think I got set up with this one. Several female coworkers complained to Humongo and HR that they don't want Kelsey in the women's restroom and that he or she, really they're using the word he, should use a unisex restroom upstairs at least until any sex reassignment surgery, something Kelsey is considering. Kelsey responds by requesting to maintain access to the common women's restroom as a reasonable accommodation for her gender dysphoria, even before any sex reassignment surgery. What are Humongo's obligations, if any? Anybody want to take a crack at this? You guys probably know. Some of you know by now that there's going to be some issues there. First question, is Kelsey entitled to a reasonable accommodation for disability? Under the ADA? No, as a matter of law, not right now. Washington law against discrimination? I don't know. You look at that statute, and it talks about accommodations. The statute for sex discrimination, well, first of all, go with sexual orientation. Since we have that in our law, federal law does not. So put away federal law and the ADA for a second. Under our disability law, you have to accommodate, let's call them medical impairments. You know that, we already talked about that. The definition of disability describes a number of things. It also then, the statute also describes or defines sexual orientation. They're a protected class in Washington, which includes the gender identity person. But the statute that let me back up. So which means that you cannot have disparate treatment against somebody because of their sexual orientation or their gender identity. Gender identity is a protected class, okay? The statute also says that you have the right as an employer to segregate bathrooms from men and women, but silent as to what degree a man or woman is and at what point in time they be a man or woman. Federal law, and here's where we go. What other laws mandate humongo accommodate Kelsey? Title VII, Civil Rights Act. It's sex discrimination. It's a form of sex discrimination not to accommodate. So there's my 2.5 or my third type of accommodation, that you have to accommodate these types of requests, and it's very open-ended. What about a coworker's opinions, hardships, things like that? The Blatt case, I touched on this earlier, that the transgender female is challenging the ADA process. But here's the Title VII equivalent of an accommodation request, and here's 2 cases. First one is out of the federal court. Employer discriminated against transgender woman in violation of Title VII, prohibiting sex discrimination. So that it's not a disability, but there was an accommodation required because otherwise to do so you would create in their minds disadvantageous terms and conditions of employment based upon one's gender, parentheses, identity. The second item up here, OSHA Guide to Restrooms Access for Transgender Workers. Notwithstanding that Washington law says you can segregate bathrooms, OSHA, you can call it up, and I don't know if you can read that from out there, but all employees, including transgender employees, should have access to restrooms that correspond to their gender identity. Not to do so will create a safety and health hazard in your employment. Remember Amy talked about how all the agencies are talking to one another? This is now an OSHA requirement, and it's not just in an industrial setting. So we have to be very mindful of that. Any questions with regards to this one? I want to move on to one more hypothetical.
Any idea why OSHA stepped into this?
Obama, I don't know. Yeah. I think it really is the agencies they really are talking to each other. DOJ also came out with a memorandum saying we are now going to interpret Title VII to include sexual orientation and gender identity as sex discrimination, which this is really filtering. Eric Holder, obviously, right next door to Obama on that. So I really think it is a collaboration type issue. That's my take. I don't know where I'm getting that, except for all the stuff that's been happening. But
it really just bubbles up from the political environment where things are going right now. So.
All right, now we're awake again. Ears are burning. 5 minutes. All right. So quickly run through this again. It's kind of a long hypo, but I really want to touch upon proselytizing in the workplace because it comes up quite a bit more often than not, or even just discussing religion in the workplace. And it's always a gray area with what to do there. So Polly is an auditor for Neutral Insurance, a private company. Polly, a Christian, believes it is her religious duty to proselytize and sway others from immoral acts, including posting scriptures in her cubicle. She also informs her female coworkers of the Bible's teaching, including sending emails that women should wear modest apparel, not gold or pearls or costly array. And I literally quoted from the Bible on this, so I'm not making this up. She does not similarly critique male coworkers for expensive-looking attire. Polly recently told a female coworker that it was not the coworker's place to question a male colleague's business plans, for a man was not made from woman, but a woman from man. That's 1 Corinthians. Several coworkers have complained about Polly's conduct, but Polly states she must preach the gospel or risk the hellfire. Polly also recently refused to sign Neutral's updated employee handbook because it contained a diversity statement stating employees must value others' diverse differences and beliefs. All right, so getting through this real quick, it's hard to see all these cases, but basically what I want to point out here is what this hypo is trying to ferret out is, one, should you ban all religious discussion in the workplace? My answer is no to that. I don't think that's actually something you should do. But you should, but to the extent that that religious proselytizing will actually infringe upon other people's rights, here's the colliding issues, that's where you really absolutely have to step in. And remember, even just talking about religion may arguably collide with non-religious employees' rights. In this case, in this hypo, one thing I wanted to point out is that Polly, in her form of religion, is also discriminating versus male versus females. She's creating, in a way, sex discrimination. This is built a little bit off of the Peterson v. Hewlett-Packard case, where a gentleman, after Hewlett-Packard started a diversity program, did want to put up, which included homosexuals and tolerance of gays, that he wanted to put up anti-homosexual policies and that sort of thing. So that actually discriminated against it. Therefore, it was an undue hardship / not a reasonable accommodation. Polly is definitely getting on that line here where she's only criticizing women about what they do, even though it's something that's based on her beliefs, biblical beliefs. And again, coworkers are complaining. What the EEOC says here, and I'll get to this on the guidance, we will send out this hypo, is that employees who are the recipients of unwelcome religious conduct should inform the individual engaging in the conduct that they wish it to stop. If the conduct does not stop, employees should report it. So just basically follow your harassment policies on what you're doing here. So don't ban religion outright, but follow the harassment policies. And absolutely, employees should immediately intervene when they are aware that this may be going on. And the part down here that I want to point out, this diversity statement is actually based on an interesting case. There was a case out of Colorado. It's called, I don't even know how to say buonanno. Anyway, this employee, because of his religious beliefs, said he would refuse to sign the diversity statement. He refused to say, I value the diverse beliefs of others, or the differences of others, including sex, gender, sexual orientation. And he says, I'm not going to sign it. And they're like, fine, you're out of here. Well, what it came down to is he was really just quibbling over the language based on his religion. He says, well, I don't want to have to value it, but I will of course follow anti-harassment policies, but do I have to sign it? That's really what he was really said he was arguing, at least after the fact. So in that circumstance, the court said that the employer actually committed religious discrimination and failed to accommodate by engaging in the interactive process of whether there was other ways, whether he even had to sign the diversity statement. Because honestly, if he didn't sign it, but he still adhered to anti-discrimination policies, what's the difference? So that's the takeaway from that case, kind of a quirky scenario involving diversity statements. And last one, we don't really have time to get to this, but this is an interesting case. There's a lot of news about Muslim taxi drivers refusing to pick up service animals because some tenets of the Muslim religion believes that dogs are actually unclean or their saliva is unclean. So there was a number of Muslim taxi drivers who were refusing to pick up folks with service animals for religious reasons. Well, there was a taxi cab driver who I believe he actually was a Muslim underlying this case, but he phrased it as a disability. He's like, no, it's not religion, it's a dog phobia. And therefore, he kind of had that higher hardship standard, so he obviously had a pretty creative plaintiff's attorney to phrase this as a disability. That being said, this Connecticut court said, well, you cannot perform the essential functions of your job, which requires picking up disabled individuals. Therefore, you're not qualified, and you are validly fired. I also think in this scenario, given the disability context, you actually have a little bit more room to actually question a healthcare provider. You might actually get some help from a healthcare provider saying, like, no, this isn't actually something that's related medically. So in this case, phrasing it as a disability actually could be helpful in a way. But at the end of the day, this case held that he was not qualified and needed not to be accommodated that way. All right, closing thoughts. We will send out this PowerPoint, but here's just kind of some highlights of what we discussed. Don't jump to conclusions. One thing I want you to take away is rarely is there some sort of insurmountable conflict between competing rights and disabilities, as we saw with the Paprika case or with the diversity statement case. There always are ways to work around this, and it always behooves you in court to be more creative rather than inflexible. So, and of course, if you have concerns, call a lawyer, because then you're kind of outbursts. I'm like, this is crazy. We'll be protected in our emails between us, all right? Okay, well, thank you. I think we've gone a little bit over, but we really appreciate it.